Hello and welcome to the final of the National Speed Mooting Competition 2025 in partnership with the UK. So we've been mooting all day long and we've whittled it down from 128 people down to our two finalists. For the appellant we have Rory Leventhorpe, and for the respondent we have Alex and So they've both done very well to progress through all of the rounds to reach the final. So we're going to start in just a few minutes, and given that it's the final, it will be 10 minutes of submissions per mooter. I'll be keeping a track of time, and your judging panel is in front of you. So I'm going to step out of the way in just a moment, and I'll hand over in a second.
May it please the court, my name is Mr. Rory Leventhorpe and I appear on behalf of the appellant in this matter, Sir Mark Newman. My learned friend, Mr. Mash, appears for the respondent, His Eminence Cardinal Bernard Jenkins. This is an appeal from a decision at first instance by Judge Thomas in deciding that it is no answer to a claim in nuisance to say that the claimant moved to the nuisance as per Sturgis and Bridgman. It is submitted that the decision to adhere to the rule in Sturgis and Bridgman was incorrect and therefore the appeal should be allowed. Before I begin, do my lordships have sight of the skeleton argument and bundle? I am grateful. May I also dispense with formal citations for time? I am grateful. The submissions of the appellant can be confined to three separate submissions. Firstly, the court is not bound by Sturgis in any case. This was a fact-specific case of residential area and of prescription, which differs here. Secondly, a new rule was made in Coventry and Lawrence regarding an exception in nuisance for noise, and these exceptions are of prescription of an easement that has been created due to 20 years of nuisance. And in the alternative, if an easement hasn't been created, the nuisance is only due to the change of land, which is a defence. I would like to begin with my first submission. Sturgis is not authority for a hard and fast rule that the appellant can never argue the respondent came to the nuisance. I would first like to remind the court that this was a decision of the Court of Appeal and therefore the Supreme Court is not bound. It is submitted that the previous decisions affirming Sturgis have erred in not seeing the fact-specific nature of the claim and have given it too wider interpretation. If I can refer my lordships to the end of page 20 and the start of page 21 of the bundle, the famous judgment in Sturgis given here clearly states that what would be a nuisance in Belgrave Square would not necessarily be so in Bermondsey, a quote that I'm sure you are all aware of. The case itself is advocating that where land has been attributed to noise, as in here, then noise is to be expected. In this case, since 1985, the land has been attributed to what can only be called noisy going-ons. Further to this, on a factual basis, the cases differ hugely. Sturgis was decided in a residential area which can never have an expectation to expect the noise that was created. This is not a residential area, it is predominantly a commercial area. On a narrow interpretation, the case is different. Sturgis was about a prescriptive easement and not a claim of coming to nuisance. I would suggest that the court is not bound. Secondly, in any case, Coventry and Lawrence created two exceptions to Sturgis and Bridgman.
Just a moment, before we move on to Coventry, going back to Sturgis, I see the point that you make, but if we look at Sturgis and subsequent judgments, judges of the highest order are very distinguished. Disagree with you. You say that there isn't. What do you say to that?
It would be my suggestion, and it would be submitted, that this is the UK Supreme Court, as I'm obviously sure you are all aware, and you are not bound by the courts that are below you. The submission has been made that the cases differ, and I think that is a pertinent decision and difference to make.
Can you help us with the point that I make, the question that I'm asking is that other judges don't share the same view that you're trying to advocate for this court. I know we're not bound, but can you help us with that?
Yes, my lord. The case of Coventry, it was declared that the court in that case were uneasy with the decision to have to follow the previous decision in the Court of Appeal. That unease can be sorted by a different decision being made in the UK Supreme Court. Not every judge that has been decided on the Sturgis and Bridgman case sits easily with that decision. Can I assist you any further on that point? I am grateful. Therefore, my second submission is that in any case, Coventry and Lawrence created two exceptions. Firstly, there is an exception to the rule in Sturgis if the right has been acquired by prescription, thus stating it is a defence to state the claimant came to the noise. Coventry affirmed that noise is capable of becoming a prescriptive easement, and if this has occurred, there is no right of claim. Lord Neuberger was satisfied that a right to emit noise could arise by prescription at paragraph 32 and 33 at page 33 and 34 of the bundle. For this to apply, the nuisance must have been running for 20 years. We must look to the facts of the case. The noise has been emitted since 1985 for over 39 years. This means that nuisance has been running for much longer than the required time of 20 years. I would further go on to state that the issue of knowledge is on the land, not the person. The land has been subjected to noise for over 20 years, and this occurred where the land had those who could oppose it in the sense of the shopping centre. It would be suggested that an easement has been created. If the court is satisfied the music could constitute a nuisance, which in this case I believe that is not in dispute, then if Cardinal Jenkins claimed that he came to a nuisance, this implicitly implies that the nuisance was already there. In other words, it has been there for 20 years and an easement has been created. Thus, either the claimant accepts there has always been a nuisance, in which case an easement arises, or the claimant's claim is that it has become a nuisance due to their move there of the site in 2018. This then brings me on to my third point. If the latter applies, then it is submitted that a very specific rule was created in Coventry and Lawrence. If I can draw the attention to paragraph 56 of Lord Neuberger's argument in Coventry at page 37 of the bundle, Lord Neuberger considered a new exception should be created, and this court can affirm that decision. Where a claimant builds on or changes the use of her land, I would suggest that it may well be wrong to hold that a defendant's pre-existing activity gives rise to nuisance, provided that, and then goes on to put forward 5 prerequisites. It is submitted that all 5 of these prerequisites are met. Firstly, it can be only said to be a nuisance because it affects the senses of those on the claimant's land. As here, the noise is specifically a problem due to the monk's devout vow of silence. The noise is not aggressively loud, it is singing. It has not been an issue before, and therefore it arises because of the claimant's use as of it now. Secondly, it was not a nuisance before the building or change of use of the claimant's land. As previously argued, this is implicit. If it was a nuisance before the change, then the claimant must accept that an easement has already been created. Thirdly, it is and has been a reasonable and otherwise lawful use of the defendant's land. It would be hard to suggest that singing is not unlawful, and never has been. The activities have been carried out for public benefit since 1985. It has also been carried out in a reasonable way. It is linked to the previous suggestion, however the music is inside in a music school and carried out in normal sociable hours of 10 AM to 10 PM. This is in line with the normal guidance that noise requirements start at 11 PM in public zones and end at 7 AM. Finally, it causes no greater nuisance than when the claimant first carried on the building or changed the use. There has been no change of use as of yet, and the activities at Simple A are continuous. It is therefore submitted that all 5 of these prerequisites is met. To conclude, it is submitted either the first exception applies, a nuisance is a long-standing nuisance that has now gained a prescriptive right of easement due to its nature being over a continuous period of 20 years, and therefore an easement is granted and there is no claim. Alternatively, it is due to the use of land that a nuisance has been created. This is covered by the new exception in Coventry. It is therefore submitted that the appeal should be allowed as the appellant has a defence in both areas. Unless I can assist the court any further, I am grateful.
May it please the court, I am Mr. Mash and I appear on behalf of the respondent. I would invite you to dismiss the appeal and uphold the Court of Appeal's judgment by finding that it is not an answer to this claim in nuisance to say that the respondent moved to the nuisance. I will make 2 submissions. First, corresponding to paragraphs 2 and 3 in my skeleton, I will identify that the long-established rule set by Sturgis and Bridgman applies in this case, and that rule states that the claimant moving to the nuisance is not an effective defence to a claim in nuisance, and I'll be referring to this rule throughout as the Sturgis rule, and I will submit that it applies in today's case and no exceptions apply. Then, to the extent I have time, my second submission, which corresponds to paragraphs 4 and 5 in my skeleton, is that the principles underlying the Sturgis rule are sound and it is good law. Now, with regards to my learned friend opposite submissions, I will mainly be responding to these with my first submission. I note that he did not raise public policy arguments of the sort that I will be addressing in my second submission. And I also note that my learned friend opposite submissions, if I could summarise them for the court, is that the law here is complicated. I submit that the law here is simple. There is an absolute rule in Sturgis, and the matter for today is whether it applies or not. And that will be the focus of my submissions, but I'm happy to take questions from the court in relation to any points raised by my learned friend opposite. And just to note in particular, I will not address in detail my learned friend's opposite submissions. The prescription applies because I know it is generally accepted that the prescription clock of 20 years only starts when that individual claimant is first exposed to the activity which is alleged to be a nuisance. But of course, I'm happy to take questions on this point. So I will now turn to my first submission, and I submit that the 19th century Court of Appeal case of Sturgis and Bridgman established a now long accepted rule of law that the claimant coming to a nuisance is not an answer to a claim in nuisance. And to see this, can I take to page 36 of the bundle, which is the judgment of Lord Neuberger in the case of Coventry and Lawrence, and specifically to paragraph 47. Would the court appreciate a brief summary of the facts of this case and also potentially the case of Sturgis as well? I see no need for this. Thank you. I'm grateful. Now, there are 2 reasons I'm taking you to Coventry and not to Sturgis and Bridgman itself. First, Sturgis was heard in the Court of Appeal, whereas Coventry reached the Supreme Court. So here we have the highest judicial consideration of this matter. And second, to be frank, the judicial drafting in Sturgis could be clearer, and I submit that it's clearer here in Coventry. So if we look at paragraph 47, you will see that the Supreme Court states that there is a generally accepted rule that it is not a defence to a claim in nuisance, but the claimant came to the nuisance, citing that this was assumed in Sturgis. Now, it's important to recognise here how sweeping and unconditional this is. It applies to all private nuisance claims, an absolute rule. There are no ifs and no buts. Now, my learned friend opposite submitted that the ratio in Sturgis is fact-specific. If that is the case, why did the Supreme Court not note it here? And I note in particular he used the language of residential versus commercial. But again, I note that that language is not present here, indicating that the Supreme Court has acknowledged this rule to be an absolute rule and not fact-specific.
Mr. Mash, can I just interrupt you there? Now, this court is not bound by the decision of Parliament. Can you help us to answer the question why this court should approve that rule, which has been consistently acknowledged to cause exceptional hardship?
There are 2 points I'd make here, my lord. The first is that no legal rule is perfect. There will always be extreme cases, and potentially today's matter is an extreme case, I acknowledge. There will always be extreme cases that cast the rule in a bad light, one might suggest, with unfair implications. Now, I submit that there are benefits to having certain legal rules that are often hard to see when confronted with a case like this. But there are certainly benefits to having a very simple point of law on often what is a very complicated manner. So I'd encourage the court.
Do you have a benefit on the facts before us?
The benefit that I would suggest, your lordship, is that going into this case, both parties would have been advised by their legal advisors that there is a clear rule from the Sturgis case, and that legal certainty will have helped the parties here in this case to make their decisions, for example, about how they arrange their commercial arrangements, and also specifically about their approach to this case today. So there is a benefit in certainty, I would suggest. I'm grateful. Now, I note that my learned friend opposite has submitted that the case of Coventry created an exception to the Sturgis rule relating to when the claimant changes the use of their property. Now, I acknowledge that Lord Neuberger certainly toyed with the possibility of establishing an exception, but I submit that he did not go so far as to actually do so. And 2 points demonstrate this. If you look at the start of paragraph 55 on page 37, you'll see that it's not necessary for the court to conclude on this point in the case of Coventry. With the words, it is unnecessary to decide this point on this appeal. Now, I submit that this signals that these comments do not form part of the case's ratio and instead represent obiter, which the court should treat as such, therefore only as a persuasive authority. And then I submit, for a second reason, that there is low persuasion in these comments. And that comes if you look at paragraph 58, which is over the page, onto page 38 of the bundle. You will see that in his conclusion, Lord Neuberger restates the Sturgis rule. Then he notes, I submit hypothetically, that coming to the nuisance may be a defence in at least some circumstances. Now, I submit that this language is far too conditional relative to the clear restatement of Sturgis for it to be considered to create a new exception to such a long accepted legal rule. At the very least, if Lord Neuberger, an experienced judge, aware of the ramifications of his words in a matter like this, would have if he wanted an exception to be created, he would have said so far more clearly. And as well, he talks about some circumstances. What circumstances? As an experienced judge, if he wanted to create an exception, he would have been fully capable of defining it more clearly. The fact he did so indicates he did not want an exception to be created here. Instead, he was simply contributing to an ongoing legal academic commentary. I submit. Therefore, I submit that the case of Coventry did not create an exception to the Sturgis rule. And as such, and to conclude my first submission, as per the Sturgis rule, it is no answer to the respondent's claim in nuisance that the appellant came to the nuisance. Now, this ends my first submission. Are there any questions from the court at this point? I will turn to my second submission. My second submission is that the Sturgis rule is sound law with sound underlying principles. And this is seen in considering the tort of nuisance as a whole, specifically how it is an exercise in reconciling conflicting property rights, here between the music school and the monastery. Now, if I can take you to paragraph 52 on page 37 of the bundle, this is paragraph 52, we're still with Lord Neuberger in the case of Coventry. As I mentioned earlier, you see that Lord Neuberger, in evaluating the Sturgis rule, noted that it is consistent with the fact that nuisance is a property-based tort, because it reflects that the right to allege a nuisance is based on one's ownership of the land. And I submit that the tort of nuisance is designed by its nature to enable such rights to be reconciled when they conflict. Now here, what Lord Neuberger is noting is that if one property owner's rights were diminished by the pre-existing activities of another property owner, such that their rights were more limited even going into the exercise of trying to reconcile them, then this would undermine the purpose and the functioning of the very exercise that the tort of nuisance tries to carry out. And I submit that instead of trying to take a risk to potentially improve a well-established law, which I acknowledge may lead to unfair implications in certain circumstances, the court should recognise that there is the principle here that is most important, is the principle that underlines the whole tort of nuisance, and that is the focus on property rights and the exercise of reconciling conflicts between them. So to summarise my second submission, the current law, as stated in the Sturgis rule, is good law, and any departure from it would represent a serious departure from a long accepted rule, and which would undermine a principle that the whole tort of nuisance is based on. Additionally, I note that the court can take comfort there are ample opportunities to factor in the nuisance's potential pre-existence at other points in the tort, such as when considering remedies. So this ends my second submission. To conclude my submissions, I invite you to dismiss the appeal and uphold the Court of Appeal's decision by applying the long-established Sturgis rule in this case. There's a final point that I will leave you with. Right now, there is widespread recognition that the UK needs to build. And I would suggest that widening the scope of potential nuisance claims would run contrary to that need. And I submit that the court must keep this in mind in its findings. And unless I can help the court any further, that concludes my submissions.
Okay, so we've had the deliberations from our judges following the submissions from both advocates. And at this point, I would like to invite Zayn Malik to come up, make some comments before announcing our winner. Let's invite Zayn up to the lectern.
Thank you and good afternoon, everyone. And thank you for bearing with us. The decision on the legal aspect of the moot is still undecided and judgment will be reserved. The justices will continue to debate that post our session here. As to the moot itself, just to ease the pain on everyone, I'm going to announce the winner. I'll announce the winner and then I'll just go through the scores very briefly, just so that there's a bit of feedback for both our competitors and everyone else in the room. Okay, so the winner of the National Speed Mooting Competition 2025 here at BPP in Manchester is Alex on my right. Congratulations. But it was not easy to make this decision, and as you can tell, we were in a very warm room, by the way, and we're glad to be back in here. Okay, and we're conscious that people have to get away and travel back and enjoy the rest of the weekend, and now that the sun's come out for the first time this year. So to very briefly go through the scores. Are you happy for me to announce the scores? Yep. So we used the scoring system that was provided to us. So each of the 5 categories were marked out of 10, 10 being the highest. I can tell you no one scored anything lower than, no one scored anything too low. So the first one is the courtroom etiquette and manner of each mooter and each contestant. Okay. For that we gave Alex 10, and for that to Rory we decided on an 8. Okay, and one of the reasons for that, if I can just briefly mention, just for your own feedback, is simple things like making sure that the judges have found the particular page that you're referencing in a bundle. Never move on, because then the judge is having to catch up with you and you might lose them in your argument. Okay, and that will affect your overall persuasiveness. So the second category is the presentation and clarity of each mooter's speech, including whether each point or aspects of it was too long or too short, bearing in mind the confines of the competition. For that we gave Alex 10, and to Rory we scored that at 9. Moving to the third one, the mooter's ability to develop the argument. This we scored both participants at 9. Okay. Moving to the fourth one, which is the use made by each mooter of each authority or other literature cited. We would have expected a similar score, and that's exactly what we witnessed. We scored both at 9. And then finally, dealing with judicial interventions. I'm sorry I put you both on the spot for that, and then I then persisted with my questioning, and you both did extremely well, because the way the question was asked to deliberately make you sweat, obviously. We awarded Rory 8 on judicial intervention, and Alex, who was able to make a good legal point on that legal certainty and the law being clear. Despite that he had to think about it and he clearly stumbled a little bit getting to that answer, we awarded Alex 9. That concludes our judgment, our results. Thank you very much.
Enjoying our videos? Then we'd be super grateful if you could take a moment and subscribe to our channel.